Well, I'm going to give the defensive display. I'm going to modify the word the defendant to a person in this case, and I'm going to use the entire instruction, including the language that indicates how a person may not be justified in displaying a firearm. I think that is pointing a firearm at a person, and so I think that language needs to be included. It is part of the entire jury instruction. If I'm going to instruct the jury as to the law regarding pointing a gun at someone, and this is a defensive display, I mean, it's I'm either going to give this instruction or I'm going to let the jury wonder. And I'm going to give the jury instruction in its entirety, or the jury's going to be left to wonder. I mean, those are really the two options.
Judge, respectfully, Judge, I think if you add the apprehension aggravated assault, you misstated the law and you confused the jury.
But how have I misstated the law if that in fact is under 90103? That is the bracketed language that I am to insert. I mean, I could literally put every crime under 90103 and 706 in there.
Right, because 90103 is referred to in the context of the defendant using a firearm during the commission of a crime. If we tell the jury that a person is not justified in defensively displaying a firearm, if they display that firearm with the intent of putting the other person in imminent fear of injury or death, then every time an officer draws down on a suspect that may or may not be armed, that officer is committing an aggravated assault, and they can't be justified by defensive display. If we read this instruction in this fashion and we adopt the state's broad use or broad definition of the term use, then anytime a person points a gun at somebody with the intent of placing them in apprehension, then regardless of how justified they are in placing them in apprehension, that person is not justified. If you read that into it and you put an apprehension aggravated assault into the justification instruction, you're basically saying it never applies. I can't imagine a situation where a person could defensively display a firearm to the point where it's an issue and there's not a concern about the alleged victim being placed in apprehension. The justification instruction by itself, just the totality of it, is from a 10,000-foot view, or looking at it in its totality. That's what it's talking about. Is when are you legally justified in placing a person in apprehension? You can't say this is when you're legally justified in placing a person in apprehension unless you're placing a person in apprehension. So the concept of the person being placed in apprehension is already presupposed into the justification instruction itself. And if you make that a disqualifier, then it eviscerates the whole thing.
In fact, it is actually in there. It is a disqualifier. Exactly. I think the judge's proposal is correct. Thank you.
Well, here's the situation. I mean, I understand it does seem somewhat of a tautological or circular analysis in this case, but in terms of does it accurately state the law in the context of the jury's question? That's what I'm trying to get at. And I'm trying to accurately and adequately instruct the jury regarding pointing a gun at an unarmed person. You know, I mean, I could just as easily see giving them the answer to 1, 2, and 4. You can rely on the instructions, your common sense, wisdom, and experience. I mean, I could certainly do that. And then there's no danger of having them decide against Mr. Jones on the basis of an uncharged crime, and they can simply rely on, you know, their experience. their understanding. But I think, Mr. Davidson, if I give this instruction, excuse me, I have to give the full instruction. And if you want, I'll put all of the crimes in there. I mean, I'll put everything under 703 and 90103. But I don't necessarily know that, I mean, that's what the instruction says. List the offenses under 706, excuse me, and 90103. That's what it tells me to do.
It says if the defendant used the firearm during the commission of the offense. Look just in the first paragraph of this very instruction. It separates out the concepts of use and attempted use. If you look at other justifications in Chapter 4, it parses things out even further, talking about use, attempted use, and threatened use. If we read use just for the purposes of this one sentence so broadly that it doesn't require the actual use of a gun, but we're also talking about just the threatened use of it, when that term is elsewhere used in Chapter 4 but is noticeably absent from this particular instruction, then we've illustrated exactly why they narrowly use the term use. I mean, consider this for a moment, Judge. If we tell the jury that this justification instruction doesn't apply if the victim is placed in apprehension of injury, what we are telling them is the defendant is justified in defensively displaying a firearm if a reasonable person would have believed that physical force was immediately necessary to protect himself against the use or attempted use of unlawful physical force or deadly physical force, unless the defendant's defensive display of the gun placed the other person in apprehension of physical injury. That's just completely illogical, Judge, and I would respectfully disagree that we're giving the jury the full instruction. What we're doing is giving them an erroneous instruction.
All right, then I won't give the instruction. I'll just tell them to rely on their wisdom, common sense, and experience.
Either way is fine with the state, Judge, but what the defense counsel just said, the threat used is still used. And they have the instruction on self-defense to decide if what his intent was is simply to actually harm people or to just be, to act in self-defense. So this goes beyond that. But if the court's going to give that, I agree with the court, you have to give that further instruction about what use is, including the threat use to place someone in reasonable apprehension of physical injury.
Okay, on all four questions, the jury will be instructed. You are to rely on the instructions, your wisdom, common sense, and experience to answer this question.
I understand the court's ruling. I appreciate the opportunity to make a record, Judge.
Okay.
I would object and ask that it be given as requested.
All righty. All right, folks, let me just a couple of housekeeping things. The jury indicated that, assuming they didn't reach their verdicts before, they were going to quit at 3:30 today. They'll be back Tuesday at 9 a.m. So they opted not to come back in on Monday. So they'll reconvene on Tuesday at 9 a.m., okay? And then, Mr. Davidson, we were trying to find, and I don't know if Carrie got in touch with you. I know those memorandums were, basically done overnight, but we don't have the filed copy yet. Could you make sure that one was sent up? If not, would you please send up a copy, the one to be filed of your memorandum?
Will be right.
Okay. Thank you, folks.
Judge, sorry, one other thing. I know defense counsel's in the valley, and if there's a verdict at some point, how is the judge, are we just going to give them time to travel up? Is that the idea?
Well, what I had decided is that if it came in, before noon, then I want defense counsel and defendant up here. If it comes in afternoon, then what I would do is I would simply ask, what I propose to do would be that all of the verdict forms be placed into an envelope, sealed with the jury foreperson's initials, and then it would be given to Cheryl, and she would keep it down in their safe. And then we would reconvene at 9 a.m. the next morning. Cheryl would bring up the envelope to the foreperson, and the foreperson could inspect it and make sure that nothing was tampered with, and then pull the verdict forms out. We'd come back in and take the verdict forms that way.
Okay. All right. I appreciate that clarification.
All righty.
Your Honor, Mr. McCowan and I were
Okay. Well, I guess I kind of, I mean, I certainly understand the need for resolution and taking the jury's verdicts. They're going to be heading for lunch. Yesterday, they went out for a walk afterwards. I think they got back to deliberations about 1:30. And really, Mr. Davidson, I think, assuming they came back at 2, I mean, we could go ahead and take the verdict, it'd probably be around 4:30 by the time we get everybody back together. But we certainly could take a verdict at that time. I tend to have my doubts that they're going to reach a verdict by 2 o'clock this afternoon. And so what I would probably again propose is that if they come back in the afternoon, that we just simply seal their verdicts and take the verdict on Tuesday morning at 9 a.m.
Okay, Judge. Just so I make sure I understood correctly, you indicated that they had deliberated until 3:30 today?
Correct.
Okay, thank you, Judge.
Okay. All right, thank you, folks. We stand at recess. Okay. I printed that out. Where is it? Yeah, I think Carrie may be gone. She may have gone to get hers lunch.